Hello everyone, welcome back to my second video. I am Siddharth Sadanand Bhatt, I am BCom LLB Inter CA, and today we are going to talk about an act which governs our very own legal profession. As an Inter CA, I had done my CA, half CA, where I had been introduced to the Chartered Accountants Act, which governs the profession of chartered accountancy. Now, obviously, we advocates who literally are at the heart of the legal profession, we also are not exactly exempt from legal regulation. So regarding this, there is an act which exists for regulating the conduct and basically the overall profession of us advocates. It is called the Advocates Act 1961. As you can see here, it was enacted on September 29, 1961. Now, what does this act govern? As you can see, it governs essentially the enrollment of the advocates with the various legal government sanctioned legal organizations, namely the bar councils. Then what are the advocates' rights and what are the duties they need to perform, and essentially the ethical conduct the advocates are required to maintain to not only protect the interests of the clients on behalf of whom they represent, whether it be in courts of law and various other transactions like while drafting contracts and all. And since as advocates, as in the legal profession, our main job is to uphold the rule of law. So this act also governs how exactly are we to uphold that rule of law. Okay, now moving on. Although the Advocates Act 1961 was enacted clearly in post-independent India, sorry, I should say independent India, nevertheless, like most of the laws in India, this act also has its roots in the British colonial era. As you can see here, in 1773, you could say this is almost a couple of years after the East India Company conquered Bengal and turned it into their first colony. So that's when the legal profession began to emerge. Essentially, the British started establishing their own courts, their own systems of education, universities and all. So that's when they established courses for law, and the legal profession started to emerge. And those Indians who graduated from these universities, they started to practice law in the British established courts. Then later on, almost a century later in 1870, the Indian Bar Association was officially formed. So now this was not an official, this was not official governance of advocates, more like informal self-governance. With the legal profession growing bigger, the advocates probably felt the need to regulate themselves. So they formed the Indian Bar Association. Then later on, centuries later, in the almost 27 years prior to independence, the now, and those of you who have read history, especially the history of our Indian freedom struggle, would know that lawyers, especially people like Gandhi and a rather unfavorable mention, but Jinnah, then our first Prime Minister Jawaharlal Nehru, they were all lawyers and they played a very prominent role in the freedom struggle. So in that sense, the legal profession was important in that age. So once the independence movement started to emerge, once it started to gain traction, the legal practice started to expand. So now obviously we are talking about the top lawyers, but there are also other lawyers who just wanted to make a living. They weren't all that interested in the independence movement. So other lawyers also started coming up. Now obviously they had different personalities, and not all of them were so scrupulous. So for them it was really all about making trying to make as much money as possible, or trying to steal cases from competing advocates, and also plenty of professional conflicts and ethical concerns, to put it in a nutshell, during this period. Then later on, short after 3 years after independence, as everybody knows, the Indian constitution was formally adopted. by the Constituent Assembly, but by the government. Around after the Constitution was established and adopted, the Republic of India came into being. Now, what the Constitution did in regards to the legal profession? One happened was, as everybody knows, there are two articles: Article 226, Article 32. Article 226, it relates to expanded access to the various high courts present in India, as essentially one high court for each state. Sometimes one for essentially sometimes one for two or more states also, but yeah, that's Article 226. Then Article 32 relates to the access to the Supreme Court. Both these articles essentially relate to filing petitions in regards to various matters before these courts. Now, prior to this, there used to be there were courts in India in the British era also, but access to them was much more limited. And regards to appeal from these decisions made by these courts, in the British era there was the Privy Council where you had to go for appeals. Now the Privy Council was in England, and not everybody could afford to go all the way there for an appeal. So when it came to appeals, there was a huge problem. So after our independence, with the Constitution being adopted, the Supreme Court of India came to be established as an alternative to the Privy Council, where you could appeal cases at the final stage if you are not satisfied with the decisions of either the district courts or sessions courts, or even for that matter the high courts. Now these two articles, they expanded access to these courts. So what happened was, legal services, the demand for them increased since it became much more accessible now. You didn't have to go all the way to England. You could now do it right away in India. Then, because of all this, the legal profession started to expand on a huge scale. Now, because it started to expand like this, the so-called informal regulations which had been in place before, mutual agreements and all, now that would no longer suffice to govern such a huge profession. Nothing less than a formal act of the government would be needed. Therefore, in 1961, the Advocates Act came into being. This establishes formal regulations with regard to advocates, like I said before, their rights, what duties they need to do, and how they have to conduct themselves at courts and with regards to their clients. It also established the bar councils of the states and the Bar Council of India, which governs all these other bar councils. And also the disciplinary mechanisms should advocates start to fall out of line with regards to acceptable ethical standards and all. Now move ahead. Now, why professional regulation became essential? I mean, obviously this is the legal profession, so it's a no-brainer, but still, why was it essential? So, number one, unregulated practice. Even today, to some extent, this problem prevails. You often hear of cases where persons, they pose as advocates in courts. They try to cheat clients, try represent cases on behalf of them. But these people, they don't actually have any qualifications. So what happens is, innocent clients, they get duped, and they are cheated of their money. They put their trust blindly in unqualified persons without being able to ascertain whether they are actually qualified to do that job. So again, this was a problem for which this act had been established, and you could say this subsists even now, which is why the Bar Council of India is even now making ever stricter rules when it comes to enrolling advocates or renewing their licenses and all. But more on that later. Then, and the next problem was, there was no ethical standards. Now, like I said before, prior to this act, there were informal codes, like the bar associations had been formed, and there were informal, verbally agreed, and maybe to some extent written codes of conduct, but these were not strictly binding. There was no central body regulating these bar associations or these informal codes of conduct to ensure their proper implementation. So again, what happened was advocates were pretty lax about their duties. So, and with the burgeoning number, especially in the independence movement era, meant that regulating advocates became a huge problem, especially you could say even now it's a thing. If one advocate or one or more behaves badly, it reflects badly on our profession. And the problem would have been even more back then when there was no formal law with regards to advocates' conduct. And next problem being, like I said, no discipline mechanism. So back then, because there are no formal rules, so it was much more easier to hide professional misconduct. Or even if there was misconduct, it was not properly defined what was misconduct. So even if one advocate wanting to do justice or whatever, he tried to raise a case against an alleged unethical advocate, the unethical advocate, he could easily argue that his conduct was not necessarily unethical in that case scenario or whatever, meaning the whole context was highly subjective. So there was no proper way, no objective way to resolve such misconduct. And like I said, informal means there was no authority that existed to ensure that advocates were suitably punished should they fall out of line. Then the next was fragmented governance. This was another problem. This bar regular associations which are established in the British era, they did not have any statutory authority. I mean, they had some form of authority which the member advocates agreed upon, but it was not formally written. It was not formally ratified by the governments in charge. And the self-regulation, this was essentially, this was all self-regulated, but this self-regulation did not prove to be very sufficient. Even now we try to regulate ourselves in daily life also. It is not usually very effective. Most of the times we do need someone or something to try to keep us in check, to try to prevent us from doing harmful things. So again, it was the case here also was the same thing. Then the next was constitutional imperative. Now, once the Constitution of India came into being, Articles 226 and 32 were formulated, and they created fundamental rights to petition to courts. I mean, even in the British era, there were courts, but nobody really bothered going there much. Most of the time, even in the British era, the British, they relied heavily on alliances with Indian princely states and all, and allowed them to maintain their own legal systems. Not everybody was satisfied with the British court system, so there was not much legal uniformity. But after independence, when the constitution was adopted, it was established as a formal right that if there was a case, then you had the right to go to the court. It was essential, and in a way it's not just right, but when it comes to criminal liabilities and all, you had to go to the court. You didn't have any choice. So with the establishment of a court system, with the establishment of a very harmonized court system, or I should say like a proper court system, the need for the legal profession to be regulated was even more so now than before, because now people knew where to go, and then and the number of advocates had also increased, so which means that regulations were more important than ever. So what was the solution for this? The solutions for all these problems: number one, the establishment of bar councils. Now, as everybody knows, there is the Bar Council of India, which regulates the law throughout the Indian Union, and it also regulates the various bar councils present in the various states. And like I said, the state bar councils, which regulates advocates and the various legal matters present in the state itself, sometimes even two states, to be sure. Then another solution was uniform qualifications. Now, because there were advocates, there was a huge problem regarding the variety of advocates and no proper regulations and all. So what happened was they created, the purpose of this act was to create uniform qualification standards. As in, right now everybody knows that if you have to do law, you do Bachelor of Law, LLB as we call it, then afterwards you do AIB, then you get a sanad, and yes, then you are established as an advocate. That the Advocates Act 1961 established. Now it is uniform. This uniformity ensures that advocates are, they all come under one body, or at least a body that is regulated by that one body, and they are properly regulated. They are kept in check. So if anything bad happens, the regulating bodies know exactly what to do. And verification procedures, as most of you know, every 5 years your COP is required to be renewed. Again, that renewal is to ensure that you are properly practicing, you have been practicing for that period. This verification procedure was also a result of this act. The other solution to the non-discipline mechanism was a binding code of conduct. Just in most acts which governs professions in India, same in Advocates Act also, they have established a specific code of conduct which advocates have to follow, not only with regard to court etiquette, but also with regard to how they have to conduct themselves with regards to the clients for whom they are responsible. Then in response to fragmented governance, they established a formal disciplinary process. Like if you have a problem and if that one body under whom you are realizes that problem, then they can institute a disciplinary mechanism against you, and you are required to appear and respond to whatever accusations they are levying against you. And if you are not satisfied with their ultimate decision, you can appeal further about it. And when it comes to a constitutional imperative, the solution was to balance public interest and preserve the advocates' autonomy and independence. As in, we as advocates, when we go to the courts, we are required to represent our clients, but at the same time, we are also needed to uphold the law. Even when we do represent clients, it's our responsibility not to cut backroom deals or not to do illegal stuff or anything that contravenes the law. More than our clients, we as advocates, our main responsibility is to uphold the rule of law in any way possible, which means as advocates, as respectable professionals in general, we also need to maintain our autonomy and independence. As in, we should represent clients, but we should try not to get too influenced by them. I mean, it is our job to represent our clients, to defend them to the best of our capacity, but ensure that we don't get too deep in it. That, we don't try to cut, like I said, backroom deals or illegal deals just so we can get an advantage, or try to do some betting sort of stuff when it comes to cases. Okay, now moving. So when it comes to the Advocates Act, what is the Act's scope and objectives? Well, one is, like I said, it regulates the legal profession as a whole, where whenever every minted law graduate, he has to first appear for an exam called the All India Bar Council exam, and after that he has to appear before appearing for the All India Bar exam. He first has to go to his local state bar council and submit an application for a provisional sanad, which is for 2 years, and after that he can appear for the exam and get his sanad fully permanent and get a COP issued. So essentially this act is responsible for that. So it essentially controls the enrollment of advocates, and it also establishes standards which advocates are required to follow whenever they are either appearing in courts or in their general practice, like formulating documents or conducting other transactions as legal aspects for their clients and all. And and the professional conduct of all advocates, which I had expounded earlier. Then number two, it protects public interest. This act ensures by and large that only those people who fulfill the requirements of the act, those people who do a proper legal course, who then register before their local bar council, appear for the bar exam, and then clear it. Only those people who are properly qualified, only they get to solicit the service of clients, and that way clients would also know from whom they are taking services. Now, like I said earlier, we get to hear news articles even today of fake advocates fighting cases on behalf of clients' behalf in court. So this fraud is going on even today. So which is why the Bar Council of India even now makes ever stricter rules and regulations. But this Advocates Act was, you could say, kind of the base platform for this. Then one is it establishes professional ethics. So this act, you could say, it formulates a very rough, not rough, more like a general set of principles, moral principles and code which the advocates are required to follow, namely how to conduct yourself in courts, how to properly represent your clients, how to essentially ensure proper legal documentation, and how to essentially try not to throw away your dignity. As a profession, you should earn money, but at the same time you should have some basic dignity as a qualified legal professional. Then it creates discipline mechanisms, like if there are complaints against an advocate for fraud or any illegal action which he has done, or any unethical action is done, his bar council has the right to investigate it, to call that the defaulting advocate for a hearing, to hear him out, and then to make an appropriate decision, uh, whether it be to suspend his license or bar him from practice for a couple of years and all. And if the advocate is not happy, he can appeal above that bar council to the Bar Council of India, and if not Bar Council of India, then to the Supreme Court. Then this act promotes the rule of law. So this act ensures that the judiciary remains independent, essentially, because advocates, they all come under the bar councils, so everybody knows who is regulating them. So what happens is the courts, on the basis of whatever decisions they make regarding this act, they can regulate the legal profession perfectly without unnecessary interference from the government or other branches of it. So that way, this act ensures the independent judiciary that was envisioned by those who made the constitution. So now, which persons does this act cover? As it turns out, everybody who calls themselves an advocate, everybody who's done a legal course, essentially LLB or LLM or whatever, and who has appeared for who has gotten a provisional sanad, who has appeared for the bar exam and cleared it, all those persons are governed by this act. Then this act also establishes the Bar Council of India and the state bar councils prevalent throughout India. Then what does this act cover? What activities does it cover? It covers representation of clients before the court, like what sort of arguments should you make when you are in court, how not to breach the line and all. Then it governs legal advice. It's not just appearing before courts. As advocates, our clients trust us to provide the necessary legal knowledge to them whenever they are puzzled with regards to, let's say, they are finalizing a contract and they do not understand this provision, or they want to ensure that the provision is somewhat more beneficial, more favorable, then it's our duty to help them. And but this act ensures that while trying to help them, we do not unnecessarily circumvent the established law. Then this act governs document drafting. As advocates, most of our time is spent in drafting all sorts of contracts and agreements and affidavits. So this act ensures that we draft these agreements, these legal documents, in accordance with whatever law is governing them, and to ensure that nothing illegal or nothing contravening the law is put in there. Then this act also has made provisions for providing free legal aid to needy persons. Essentially, the bar councils, there are specific there are specific offices where which make provision for providing free legal advice to these needy people, like poor people and all, who cannot afford the usual fees for advocates. As I think everybody knows, if you do not have money to, if you are being prosecuted and you do not have money to afford an advocate of your own, it is the duty of the government to appoint an advocate for you. But my advice would be, it's best not to take the government's choice, because most of these government appointed advocates, they usually are not very skilled. So it's best to appoint your own advocate after ascertaining his skills. But if you are very poor, you don't have that choice. So it's, this legal aid is very beneficial, very helpful. It ensures that no one is unduly deprived of necessary legal aid just because you don't have the financial resources. Now, what is the territorial applicability? As in, how far does this Advocates Act apply when it comes to the territory? Now, as it turns out, the entire territory of India. Until now, Jammu and Kashmir was exempt somewhat, but after Article 370 was repealed, even Jammu Kashmir now comes under this jurisdiction of this act. Then the Bar Council of India, the Central Bar Council, you could say, for all of India, it coordinates how the standards are being implemented and how advocates are regulated throughout the Indian Union. Okay, now moving ahead. Structural framework. Now, this Advocates Act, it has something like 60 sections across 7 chapters. Chapter 1 relates to bar councils. Section 3 to 23, it talks about establishing the bar councils. Then what is the composition, as in what are the number of members in the bar council, then their hierarchy and all, and what powers do they have, as in what they can do in accordance with whatever the act has enabled them to do. Chapter 2 relates to enrollment of advocates. Essentially talks about what is the eligibility criteria for the advocates, then what is the process to apply to be an advocate, then verifying as in whether you have the proper credentials and all, whether you have done, well, essentially proper credentials. Then obviously after all this, what is a certificate issued which verifies that you really are a fully qualified advocate who can practice in a court of law, or who is qualified to conduct general practice. Chapter 3 talks about rights and liabilities. Essentially, what are the rights granted to advocates, and in practice what specific privileges do we enjoy. Then chapter 4 is about duties, namely what duties were we mandatorily required to perform, and what ethical obligations we are required to follow to ensure the dignity of our profession, and also to prevent ourselves from being blacklisted by the bar councils. Then chapter 5 talks about disciplinary jurisdiction, as in if we are to do anything wrong, then which bar council is authorized to investigate us, and in what way they can initiate disciplinary action. Then after the jurisdiction, chapter 6 talks about the proceedings, like after the investigation is initiated, what is the proper procedure for that investigation, how to conduct the hearings, within what time the hearing should be conducted, what sort of evidence can be admitted during those hearings, and what sort of decision should be made. Then obviously last chapter, chapter 7, is that if you are not satisfied with the decision of your local bar council, in what way you can appeal to the higher authority above that bar council, and various other provisions. We will check that later. Now, this Advocates Act 1961 is the primary act which defines the legal profession, which defines who can be admitted into the legal profession. This admitted, now according to this act, anybody who is a part of the legal profession, who is fully authorized to practice in said profession, is called an advocate. Now before this act, there used to be various legal practitioners. There used to be muktars, revenue agents. Then that I am sure everybody knows that advocate in colloquial Indian language, Hindi mein it's called vakil. There used to be vakils also in the pre-independence era. Essentially a variety of legal practitioners under different names. So nobody knew exactly whom to trust, whom to go to in case you had a specific problem. This act resolved all of that. It brought all of those legal practitioners together under one single term, aka advocate. Now, who is an advocate? Now, the definition of an advocate as per this act is this person, whoever he calls himself an advocate, he has to be enrolled by the state bar council in whichever state he is residing in. If that state has the bar council, he has to enroll with that bar council under this act, and he is authorized to practice law. He is authorized to draft legal documents, to put his signature and stamp on them, to essentially declare that this document is validated by him, and is also authorized primarily to represent his clients in courts in whatever cases he is charged with fighting. Now, what are the legal qualifications that a person needs to be an advocate? Like I said earlier, the the primary qualification is an LLB degree or Bachelor of Law, if you want to use the more formal term, or any equivalent from a recognized university, essentially a university which is officially recognized by either the Bar Council of India or by the state government or central government. Then there is a prescribed apprenticeship period which you are officially required to complete. Now most of us, if we are like doing another course and all, we usually don't do this. We don't usually, the apprenticeship is not exactly compulsory, but it would be beneficial if you did it, since it helps you gain a hands-on experience of law, which would be very useful should you decide to go into full practice as a full-time advocate on your own. Now, what is the minimum age qualification to be an advocate, and what is the citizenship? As in, what citizenship do you need to be an advocate? Now, that's obvious. When it comes to citizenship, you are required to be a citizen of India, which most of us are. But there is, you could say, many foreign advocates also come, those from outside India. Could they be admitted as an advocates? The answer is yes. India is a member of the Commonwealth of Nations. This was established shortly after India's independence by Britain as an alternative to the British Empire, which was dissolving. You could say it in some way the British Empire carried on even when it was officially gone. You could say in a political form or a spiritual form, in a way, in spirit. The British Empire carrying on its legacy in spirit, in a way. So, well, in former territories of the British Empire, if those people also come here, then they are also qualified to be called advocates as per this act. Now, character and conduct. Now, just advocates, just like every other profession, they need to be of good character. You must try not to do illegal stuff and all. Then, when you are enrolling as an advocate, those of you who have done law students, and especially if you are listening to these professionals who have enrolled as advocates, you know that the Bar Council of India in its enrollment form does ask for whether you have been convicted of any crimes before. So they do this to ensure that their profession is not tainted by any potential criminals or people who have the potentiality to commit any crimes in the name of the legal profession. Then moral turpitude or professional misconduct. If you had any prior history of any professional misconduct, like if you are not advocates, if you are under some other profession, and you had committed some crime under that profession, that also could be a ground for the Bar Council of India or the State Bar Council to refuse your admission, or at least to keep it pending for much longer. So what disqualifications should be as in, and what you should not possess? One is, you should not be an undischarged insolvent. Put it simply, you must not be a bankrupt person. The bankrupt persons, the bar councils will not admit them, or even if they do admit them, they will be placed more strictly under watch, or they would be monitored more closely, or their applications be kept pending for a longer time until they resolve their bankruptcy. Then they should not be of unsound mind. Essentially, they should, like I said in my prior video relating to Contracts Act, they should be capable of understanding what they are getting into, capable of understanding the weight of responsibility and duty that their profession entails. Then they are, like I said earlier, they should not have been previously convicted of any crimes, especially crimes involving morality and all. Then what happens though if as an advocate you do some illegal stuff, or you do actually become a criminal? So what happens is, the Bar Council of India maintains a document called a roll. In it, it keeps a list of all the advocates who have enrolled with it so far. Now, if you are convicted of any crime, or if you are suspected of it, your local bar council is entitled to simply remove your name from that roll. Meaning, you are no longer qualified to practice as an advocate in any manner whatsoever. And it gets even worse. Even if you do continue to carry on with illegal stuff, or even if you have done it before, if they remove you, they can prevent you from re-enrolling again. And it's not the bad thing, is that even if you do attempt to go to another state to re-establish yourself as an advocate, the State Bar Council is fully authorized to inform the other. It's not just fully authorized, it's their duty primarily to inform the State Bar Council of the state where you have migrated to, of what immoral deeds you have done while you are an advocate, to ensure that you don't enroll there either. So either way, doing immoral stuff as an advocate can be a practical death sentence when it comes to a legal career. So best not to do it. Again, the others who are disqualified are non-citizens. So either if you are not an Indian citizen, or if you are not from the territories of the former British Empire, or territories not designated as Commonwealth, to keep it simple, and you come to India, that would not make you an advocate in any manner. You could say even enemy nations, like if you are from Pakistan or China and all, that would not, the Indian government, the Bar Council of India, or the State Bar Council of whatever state you are in, has full right not to admit you as an advocate. Now ahead, what's the enrollment process? Now now there's obviously a process for enrolling yourself as an advocate. So what are the steps here? Step number one is you have to submit an application. So what does the applicant file? So what does the applicant do? The number one, as those of you professionals would know, you are first required to file an LLB certificate, as in when you do an LLB degree, you are issued, after completing all semesters and finally clearing the course, you are issued a passing certificate. So you are required to file that. And if you've done apprenticeship, or you could just say an internship, you could submit proof of internship. It's not compulsory, but it's better if you do. Then some character references also when it comes to State Bar Council. Of course, it's not just LLB certificate also. You have to required to submit the mark sheets of all the semesters that you have appeared in while you are doing LLB. So there is that. Then the bar, once you have submitted all this, the application form, the LLB mark sheet, certificate, and whatever other documents you did, the State Bar Council will take its time to verify all this. Verify whether you have actually done the course at the university which you claim to have done, and if you have done internship, whether that internship has actually been done under whatever advocate you were doing. Then as you would know, those of you submitted forms for provisional sanad, they also ask for police verification, as in you are required to verify, submit a police verification certificate stating that you are a fully law abiding citizen, that you have no criminal background, Then they would do some reference checks if you've done apparent internships and all. They would not just internships but also when it comes to criminal background, they would probably ask sources from those persons, not your whatever references you put. They would probably call them up and ask if there is any criminal history with you. Then they would verify your overall background, and there is a minimum 10-day notice period. In my case, so when they took like something about a month to fully verify the form. But I guess you are required to provide a 10-day minimum notice period. I have no idea about this, but it would be best if you verified this. Then there is an enrollment committee which obviously checks this form completely which you have submitted, and they might do a personal interview. Nowadays the interview mostly happens by call. Those of you who enrolled already will know, after you submitted this form and all the related documents, after a month or two you get a, or sometimes in between also you get a phone call from the bar council stating, essentially verifying whether you are a real person or whether you have done all or if you have had any mistakes in your application, what sort of mistakes were there and how you can correct them and all. Then after all this, the bar council either grants your enrollment or it can reject it. Rejections I wouldn't know, but it usually grants it. If it is rejected, I suppose you could appeal against the bar council for finding out reasons as to why they rejected, or trying to rectify any mistakes either on your part or trying to get the bar council to do so if it is on their part. Best thing to do, I would say, just do your enrollment properly, do the LLB course, do apply for the provisional sanad properly with all proper documentation, it will flow smoothly. Then there is when you are submitting all these documents, the documents also include an affidavit. That affidavit essentially consists of the oath which you are required to fill out, uh, namely that you would fully abide by the rules and regulations of the bar council, and you would uphold the constitution, and that you would be an ethical advocate and whatever. Essentially you are just required to fill out the affidavit, get it, sign it yourself and submit it along with all the documentation. Now after all this, the bar council, the state bar council, they issue a enrollment certificate, essentially a provisional sanad. Then this provisional sanad, once it is issued, as an advocate you are finally authorized to practice within the jurisdiction of wherever you are at. If it is Mumbai, then bar council of Maharashtra and Goa's jurisdiction, you can practice in any district sessions court, or for that matter even Bombay High Court. And if luck is with you, you might even get to go to the Supreme Court. But of course, after this provisional sanad is done, you are required to pass the All India Bar exam within the 2-year period after you are enrolled. And once you clear the bar exam, your sanad gets permanent, and you get issued a certificate of practice wherein your status as an advocate is fully cemented, so to speak. Now, as legal professionals, we do have rights. The rights is something that has been provided by Article 14 of the Indian Constitution to every person. Now, obviously, as legal professionals, we do have our rights, right? We need to. We, after all, are in charge of the legal profession. So, what rights do we have? Number one, our right to practice in courts. We as advocates, we do have the right to appear before clients across various state courts like district courts, sessions courts, and if you are lucky, you get to practice even before the high court of that state. And if you are even more lucky, you could go to the Supreme Court as well. Now, okay, for that Supreme Court, it requires another enrollment. As most of you, those who are advocates, you have been enrolled with the state bar councils, right? Now, for Supreme Court, you need another enrollment. You need to enroll with none other than the BCI itself. Since they regulate advocates all over India, they are a centralized body. So it makes sense that to appear before the topmost court of India, you are required to enroll before the topmost legal authority when it comes to advocates. Then right to legal representation. You have, as advocates, it is our exclusive right to conduct litigation. No one else can do it. In fact, if you ask me, even when it comes to collaboration with other professionals such as chartered accountants, those of you are doing tax law and all, chartered accountants, they do get involved in tax law. But even then, they cannot appear before the income tax tribunals or whatever other courts are there for tax law. We as advocates alone can do so. Essentially, put it this way, non-advocates or other professionals, they can do some legal work on behalf of their clients. When it comes to courts, we advocates alone have the privilege to appear before it. Then our another basic right is to charge and recover fees. This is a no-brainer. This is for every profession. For whatever legal, whatever services we or for that matter other professionals do, it is our right to charge the reasonable amount of fees in accordance with the quantity and quality of services we have rendered. And if the client proves uncooperative, we can initiate court action to recover those fees. Then we can disclose what fees. Essentially, just to put it simply, it's our right to charge and recover fees. It's not exclusive to advocates. Every profession has this right. If for that matter, even when you do a regular business also, if you are not a qualified professional also, it's your right to recover money. So it's a no-brainer. So again, attorney-client privilege. Now this also something that's there in every other profession also. If you are dealing with a client, whatever communication is there between you and the client or whatever documentation is maintained, it is your right as an advocate to fully, not just right mind you, but also duty to protect all those the records of those meetings and transactions or communications and whatever documentation you kept regarding those from public disclosure. In most cases, if you can claim client confidentiality as a defense if you are asked to disclose the communications. That said, there are exceptions, namely for one crime is fraud. Fraud is considered fraud usually affects not just one client but several other clients. You could say it's a public crime. So if it comes to fraud, which affects a large segment of people, the client confidentiality does not apply. If the court asks you to disclose whatever dealings you made with the client, you should disclose them. Then if the court determines that it is in the public safety for some reason to disclose those communications or documentation of those meetings and all, then you are required to do that. In a way, the court is pretty much the supreme authority. Not supreme authority, but it definitely ranks above advocates. If in criminal cases especially, it's best to disclose all this client confidentiality stuff before the court. Or when it comes to, or rather it comes to fraud and public safety. Again, public safety is somewhat subjective. It depends on case to case. Some cases will not usually be public safety. Like you could say family law cases are not public safety. They are exclusively private matters. So their client confidentiality is a necessity. You could claim it as a defense if you are asked to disclose your dealings with clients. But when it comes to crimes of terrorism or warfare or anything, then this does not apply. Then you have the right to have immunity from civil liability. Like for say, as an advocate, if you are practicing in court or you are conducting other professional pleadings outside the court proceedings, really, like drafting documents or putting your signature and all, then you have the right to be protected for all that. As in, if you are just doing your duty, if you are not going out of your way for your client, and if you are just doing what duty you are supposed to do, then you have the right to be protected from that. Just like how public officials working for the government are usually granted protection from the consequences of the duties they rightfully perform. Of course, not for any illegal dealings or any extra legal duties which they have done. There is no protection for that. Then professional discretion. As an advocate, it is not just your right, but it is also your duty to try not to accept cases which you feel are immoral or unethical. That said, advocates do accept cases on behalf of suspected criminals also. So it's not really a crime. But if as an advocate you feel it's not proper to represent him, then that's your full right. You cannot, yeah, it's not your how to put it, it's not a compulsion to that you have to take on every case. That said, refusal cannot be discriminatory, as in if or say some poor client comes to you and if he is in very urgent need of legal aid, then as per the act there is a specific criteria where you are required to provide free legal aid to very poor clients. There you cannot refuse saying that I'll not do this for him because he doesn't have the power to pay, especially if he's a very needy client. Or especially you cannot discriminate on behalf of, let's say, the caste of the client. Like say if he's an supposedly if you think he's an untouchable and you do not want to represent him for caste reasons also, those are not allowed and all. Then number one, last right is participation in bar governance. This is usually something that's asked to us whenever we try apply for sanat, like which bar association you are going to register in, and where are you going to vote. As in, it is your right and you could say duty to vote in bar council elections. Usually they, when you are enrolling, they ask you where exactly you are going to vote. So that is there. Then you could hold off, then you have the right to hold office in court or in the bar council and all. Then as advocates, it is your right and more importantly a duty to contribute to the regulation, standards and overall professional development. Obviously, as advocates, we alone are responsible for our profession. So it's our duty to try to make our profession better in every way, to make it safer, more ethical, more responsible, and in a way, try to make it the best possible profession ever for people to enter in, to enjoy working in, to do their duty properly, to uphold the rule of law. It is only when we all uphold the rule of law that then we are all safe. Okay, now ahead. Now, when it comes, now not just advocates, but every person, the Constitution essentially says that for every rights you have, you also need to perform equivalent duties as well. That essentially it's give and take. If you want to take something, you must give something in return. Now, duties involve giving. Now, as advocates, what must we give? Number one, our duty to the courts where we fight cases. Now, we should try to avoid making false misstatements or fraudulent statements or trying to conceal, unnecessarily conceal facts. As advocates, it is our duty to lay out all the facts of a case and properly present those facts in the from the perspective of the provisions applicable to those facts. Then and our next duty is to disclose adverse legal authority. Like if you believe that this court doesn't have the jurisdiction or the authority to try it, it is your duty as advocate to try to point this out, not unnecessarily take the case further just because you want more money. If you try to do so, the consequences will be pretty bad. If the court finds out, you could be heavily penalized, you could get suspended or lose your bar license and all. Then, more importantly, uh, when it comes to court, if the court has designated a specific time for a hearing, it is your duty to appear precisely at that time or as close to that time as possible for the hearing. The courts are usually very busy. They have cases ongoing throughout the day. They don't really have time to wait for you. So it is your duty to appear at the court at that point in time. And if when a fighting case and the courts issue interim orders or final orders, you must comply with them. If you do not comply with them, the court has the full right to issue contempt of court order against you, and as an advocate you could be heavily penalized. It's not just suspension of bar license, you could even go to prison. There's a provision in Contempt of Courts Act which specifies imprisonment for holding contempt of court. Then you should maintain decorum and respect. In courts, it is important to maintain silence, to only speak as much as is necessary, like stating your arguments and all that. Most of the times, it's best to keep your mobile phones on silent mode, or best to put it off. Then you should, as an advocate, you should always dress in black and white, as in black overcoat, then a bar tie, I think, and a white shirt and black pant, and a pair of formal shoes. Then you should try to avoid contempt of court, or try to avoid speaking extremely disrespectful language. Again, speaking disrespectful language gets advocates under contempt of court order with the consequences which I have just stated to you. Then, now court is over. Now obviously as advocates we are really doing the work of our clients. So what is our duty to them? Number one, when it comes to providing legal service or legal advice, we should provide the proper legal advice. We should do research, and we should find out what sort of legal provisions are anything is applicable to the situation which the client is in. On the basis of that, provide legal advice. You must try not to mislead the client unnecessarily, or try to be careless with the client. Otherwise, not only could we lose the client services and our money, but we could also get issued disciplinary proceedings against us in a way. And you should only accept matters which you feel you are capable to perform. Not only, essentially, you should accept matters which are perfectly legal to do, but also those which you are only capable to do. Not try to unnecessarily overextend your capabilities. Otherwise, you would start questioning yourself, and you could end up rendering poor service anyway, especially if you are in a hurry. And you could lose the client's trust and his services permanently. Then, second duty to the client, like I said earlier, it is your duty, whatever communication you make with your client with regards to cases, whatever documentation or recordings you keep with regard to those meetings you had with your client, you must keep them confidential. You must try to and if when you are fighting in a case, if the opposite party asks for the disclosure of those communications, it is a duty to protect them. Unless, of course, it is a criminal case and the court feels that it's in the public interest to disclose those, then you have no choice but to disclose them. Then, as advocates, obviously it's our duty to act in the best interest of the client wherever possible. That said, when trying to act in the best interest, we should try not to act out of our way or try to circumvent the law or anything like that. At the same time, if we must try to avoid disclosure of avoid conflicts of interest. Like it happens sometimes, especially within legal families, where if you are a young advocate and you are appearing before a judge who happens to be your a close relative of yours, then it is your duty to not appear before that judge, since the outcome could end up being unfairly influenced in your favor and could be a case of professional misconduct. Then next duty is, if the client provides some money to you and asks you to keep it in trust for him, like if he's doing some business and he wants you to do some work for him, and so he's entrusting you some money to keep for him until he comes back or until he's finished whatever he means to do, then you should not keep that money in your personal account or anything. You should open a separate bank account, and you should deposit the money in that account only. And essentially you should try not to mix the client's money with your own, unless that money is your fees. So you should maintain a separate account, and you could charge fees for the upkeep of that account as well if you want. Then what is the duty to the profession? Essentially as advocates, we all are part of the legal profession. So what is our duty to it? Number one, we should try to maintain professional integrity, as in we should try to try to be moral persons as much as possible. We should not just in the professional but also in our private lives also. We should try to avoid any form of scandals, which means like is written here, we should avoid conflict bringing disrepute. Essentially, we should not try to get into matters which could end up being potentially damaging to our reputations. Otherwise, we are liable to be removed from the role of advocates, and essentially our legal careers could be severely damaged. Then if there are cases of of discipline, like if you are not being, if the bar council finds cases of professional misconduct against you and they initiate investigations, it is your duty to cooperate with them. If they summon you for a hearing, it is your duty to go to the hearing at that point in time only. You must try not to skip it. Otherwise, skipping it would mean that passing an ex parte order against you, as in the court, the bar council would decide that you are guilty somehow and pass the order against you. Then when it comes to conducting yourselves in those hearings and all, you must try to follow the proper procedure and decorum. Try not to create any unnecessary ruckus. Then more importantly, as advocates, we are all independent legal professionals. We all have worked hard to be here. We have done years of study. Then when it comes to appearing for the bar exam, we had to study all the bar acts and also we worked hard. So to preserve that hard, so preserving our independence is also important. We must try not to become completely dependent on a particular client, or try not to essentially become his or her servant. We should try to do our best with our client, but at the same time we should keep a distance. We should remember that we are independent professionals. We are regulated by a governing body who can heavily penalize us for any misconduct on our part, and there is no defense saying that you are authorized to do anything on behalf of your client. The bar council specifies limits and you have to follow those limits. And more importantly, you must try to refrain from stealing clients of other advocates. As in, of course this happens, it's not completely avoidable. Everyone has to make a living. So stealing clients from others is something that always happens on another, but it's best if you try to limit it. It's best if you try to build your own client base by proving your own worth to them. It's much safer, and you can avoid cases of misconduct being filed against you, especially if those other advocates find out and they try to take action. Then this is not a compulsory duty, but it would be best if you try to contribute to the overall development of the legal profession and continuing legal education, as in you could try to give lectures or try to at seminars, you could try to expound more on, you could give more information regarding the amendments in law and all, or essentially trying to educate people as much as possible on the basics of law, how to protest, safeguard their rights, how to make use of them, and so on. Essentially trying to avoid as trying to protect those people who are ignorant of the way the law works from those who know better or try to exploit them for their own ends. Then, as advocates, our legal profession is also a public profession. We render a sacred duty to the public to uphold the rule of law, to fight for the cause of justice for them. So, our duty to the public is also very important. So, what should we do? Number one, we should provide legal aid, as in those people, those persons who urgently need legal aid, but they do not have the money to pay us. It's our duty to try to provide them legal aid as much as we can and the best way we can. That way, the reputation of our profession is enhanced, and more, and it helps us, all of us individually in the long run. We all benefit from a more enhanced reputation. If we provide better legal aid to them, it enables us to attract moneyed clients and provide better service, and in a way it's best for us in the long term. Then we should all promote access to justice, as in we should ensure that nobody is substantially obstructed from uh, being provided justice for whatever they have suffered and all. And we should uphold the values of the constitution. The whatever articles are in there which propound those values, it's our duty to uphold them. Upholding them would mean we essentially our reputation again is enhanced, and we essentially we all benefit. We must not forget that the Constitution of India was drafted by lawyers. In fact, our independence movement was fought by lawyers. So our legal profession goes way back. These people have established standards, and it's our duty to try not to duty to try to ensure those standards are not corrupted. Of course, it happens from time to time, we cannot prevent it, but we must do our best. Then we must do our best not to participate in illegal activities. Even if you are tempted with a lot of money, quick, easy money, it's best to not participate in it. That way, you avoid the consequences of case misconduct proceedings being filed against you. You avoid your license being taken out. Essentially, it's best not to lose your long-term source of income or your reputation just because you wanted to make some quick, easy money. Then you must report serious misconduct. As in, if you come across any misconduct on behalf of your fellow advocates, if it goes unreported, it could have a serious ripple effect across the profession. One advocate's bad act or even a couple more, it could reflect badly on the profession as a whole. Our whole reputation could get stained. So it's best to report misconduct as quickly as possible and try to ensure that it doesn't, as I try to ensure that our dignity is intact. Then you should maintain standards that protect the public interest in legal. When you are performing legal services, there are standards which the Act enunciates. Not just that, there are general moral standards also, which you should uphold, which you should yourself follow, and you should try to protect the public interest as best as you can, because protecting the public interest means protecting your own interest in the long run. If the public interest is not satisfied, not only could your private interest get adversely affected, as in courts, as someone with a grievance against you could file a case and you would be in deep water. So for your own safe or long-term safety, it's best if you remain ethical. Then conduct standards. The standards you must follow must be honesty. When you are in courts, especially, the perjury is a very serious crime. Perjury as in lying on oath before the court, giving false evidence and all. If the court finds that out, you could you could be very severely punished. Like you could get sent to prison, pay fines and all. So for your own good, it's best if you try to avoid perjury of any kind, and if you deal honestly with the court. And also with clients also, maintaining trust with them helps to not only ensure good relationship but also ensure a steady source of income. So it's best to be truthful with them as well. Integrity. Try to avoid, not just for advocates but all other professions also. It's best to avoid getting into any financial scandals of any sort. As in, if you are dealing with clients, if the client asks you to do something illegal, just don't do it, because you have your profession to look after. You cannot sacrifice your profession, your dignity, more important, your reputation, and more important, and your overall safety and career, just because that client is very high paying and wants to benefit from you, or is offering more benefits to you. Then confidentiality. Like I said earlier, client confidentiality is a sacred duty not just in the legal profession but in all professions. So if the law compels you to do it, then only then you should do it. Or if your client consents, or if you feel that you should the communication should be disclosed, you must consult with the client. If the client says okay you can do so, then you should do so, otherwise no. Then if there are matters which are coming up to you as an advocate and you fight in them, only to find out that those matters are matters in which you have personal interest, like say if you are fighting on behalf of a client, like say a company where you personally hold shares of a very significant amount, or where like I said earlier, the judge happens to be a close relative of you, you must not take up those matters, or you must not appear before that courtroom. You should get that case transferred to another unrelated judge. Okay, now moving ahead. Confidentiality and attorney-client privilege. Like as we talked about before, this is a very sacred duty, privilege and duty, not just when it comes to legal profession, but to all professions. Where when our relationship with the clients is a matter of is a sacred right. Basically, the client puts his trust in us. The client is not able to do stuff on his own, so he relies on us to do it for him, which means he trusts us. That trust is a very sacred part of the profession, and we must try to uphold that trust. So that's the basis of the confidentiality and attorney-client privilege. So what's the statutory basis for it? The Indian Evidence Act section 126 provides for protecting that confidentiality thing, except in very specific circumstances which I've enunciated before. Then the Advocates Act section 31 to 35 and 49 also provide for this. So what is protected? One, whatever legal advice, opinions and counsel you have provided to your client in any manner whatsoever. You could say if the client discloses that he has committed some crime which is relevant to the case, that is also it is also your right as an advocate to protect that information. In fact, it's a duty to protect that information. You cannot unnecessarily disclose it just because you think it will help your reputation as an advocate more, or you could personally benefit in a way. Then what is protected? Again, like I said earlier, facts disclosed by client, that what I was talking about earlier, any crimes he has committed in the past which are related to the case but which he hasn't done yet, so that is also fully protected. Then again, protected is between you and client. There is a you can't always make oral communications and recordings, so there is documentation that's passed on, documents of communications, or whatever other stuff you've been doing. You essentially keep a diary where you record everything that you talked about, so that is extremely privileged information. It is your right to not disclose it unless it is absolutely necessary. Written would be either physical letters. Nowadays physical letters is not much of a thing, so into modern world it is the email. Then whatever documents relating to the documents you present in court, that is also protected. Then when you are preparing for litigation in courts, there are materials which you use to prepare for it. Those materials are also confidential information. It's your right to not disclose it, and also duty in a way. Then however, there are exceptions to this. If you are disclosing, if you are keeping anything from the court which relating to the client, which only enables that client to commit further crimes or perpetrate further fraud, then client confidentiality is no excuse. Then the court says you need to disclose it to them, if only to protect other people from getting hurt. Again, like I said, public safety exception also is a thing. Like I said earlier, if the court feels that for the safety of the public, to prevent further harm, such confidentiality needs to be disregarded, then it must be disregarded. Then holder of privilege. This privilege essentially this privilege is more with respect to the client, not the advocate. Actually, as advocates, you could say disclosing that such information might actually help our case in some ways. But the client has put his trust in us, so it's ultimately his privilege. It is his right to keep secret in a potentially compromising information. However, for client for some reason may waive that privilege, may say, okay, you can disclose my information. Then you as an advocate can and should disclose the information because this is not your privilege. This is the client's privilege. The act has provided this privilege to the client, not to advocates. So this privilege is not an independent one. Then what happens is if waiver by disclosure, if client shares communication, so this private communication, it should be strictly kept between advocate and client. For some reason, if the client decides that it helps him better or gives him more security or whatever, he more leverage, he decides to disclose facts or circumstances to another party, like a relative or another advocate or professional whom he trusts much more, then this privilege is lost. Then as an advocate, you have you have the duty to disclose that communication because the client uh, did not exactly put his trust in you. He relayed the information to other professionals also, meaning he doesn't trust you as much. So you are at full liberty and duty to disclose it all. So however, there are some common misconceptions regarding this. Some people believe that confidentiality means, yeah, it's your full right to not disclose just about anything in court. That's not true. Confidentiality is subjective, not objective, not absolute. So for instance, WhatsApp messages or Instagram posts or anything you put in social media or anything you put on the internet, or if you've done any business interactions, um, then those are unprotected. To put it simply, anything you post on internet or social media is not exactly protected because social media is public. By posting anything in social media, your confidentiality cannot possibly be maintained. So obviously, social media posts, the court can ask for that as proof, as evidence. Confidentiality doesn't apply there. Okay, now next, what is this act now? As I said before, it establishes bar councils to regulate advocates. At the top of this hierarchy is the Bar Council of India. The section 4 of this act established this. Now Bar Council of India is like the centralized body which governs all the other bar councils prevalent throughout India, advocates throughout the state. And when it comes to standards for advocates, this is the one council that ensures that standards are formulated and followed throughout India as one. No variations for states. Now, obviously, Bar Council of India cannot do everything on its own. So, under that, there are state bar councils. There's under Section 3, this was established for each state. Sometimes even for two or more states. Like those of us who live in Maharashtra, we know that the State Bar Council of Maharashtra is also has jurisdiction over Goa. So essentially, sometimes if a state is small enough, or if they have come to an agreement, the Bar Council's jurisdiction can apply to two or more states. But anyway, the State Bar Council is primarily responsible for enrolling advocates living in that area, then for enforcing discipline among advocates, essentially conducting investigations of misconduct and all. Then within each state territory, it has the responsibility to formulate and implement rules. Then what are the governing principles, the governance principles, so to say? One is there is a democratic representation, as in the leaders of the bar councils or those advocates who run the bar council. There is a periodic election held every couple of years where all advocates are entitled to vote at the bar associations where they have registered, and after the elections are complete, the specific advocates are elected to run the councils. They are responsible for judicial oversight, as in, obviously, since they regulate the legal profession, they are also responsible for ensuring that the judicial system has proper oversight, as in they oversee the proper judicial system, ensuring its independence, its integrity, and so on. Then it also ensures that the advocates are accountable for their conduct before the bar councils. Like if they have done something wrong, they have the bar councils have the right to conduct disciplinary proceedings against them, and there are appeal mechanisms as well. Like if you are not satisfied with the decision of the state bar council in a disciplinary case, you can go to the bar council of India. If not, bar council of India is also not satisfactory, then you can go to the Supreme Court. Now, what are the key powers and functions of it? When it comes to state bar councils, they have the power to enroll eligible persons as advocates. Then they have the right to enforce discipline. They have the right and duty to make rules governing conduct of advocates. They have the right to maintain professional standards, and so on and so forth. Now, moving ahead. Professional misconduct. What is the definition of professional misconduct? So professional misconduct means this act has specified a code of conduct of ethics which every advocate is required to follow. If the advocate violates any of those any provision of the code, then that means he is guilty of professional misconduct. And also, not just the code of conduct, when it comes to client, if he misuses his client's trust in any manner whatsoever, that is also professional misconduct. And as advocates, you have your duty to the public. If an advocate decides to go against the public interest and safety for his own personal gain, that is also professional misconduct. Or bringing disrepute to the legal, if he is like involved in any scam, any financial scam or something, especially relating to a client with whom he's in a business relationship, that is also professional misconduct. So what is the conduct prejudicial to profession? One is, if you as an advocate are convicted of a crime, or any crime really, or if you have done some fraud, like if the client entrusted his funds to you and you kept it for yourself, you misappropriated in any way, or let's say if as an advocate, if you had a stressful life, so yeah, it's obvious to try to relieve yourself by consuming alcohol or drugs. But if you consume too much of it, and if you are known as a drunk fellow or a drug abuser, then that is also a problem. Then ethical breaches. Like I said before, it's important to maintain honesty, especially before courts. So if you before courts you commit perjury, or if with your own clients you try to conceal information or outright lie to them unnecessarily, or even to the opposing counsel also, just so to advance your own cause at whatever cost, then that is also an ethical breach. Then conflict of interest. This essentially, like if say you're representing one party in a case, but for some reason to make more money, you decide to represent the opposing party as well in secret. Now obviously as an advocate, it's your duty to fight for one party. You can't fight for both parties simultaneously. That's also serious misconduct. Then as an advocate, the Bar Council of India has laid strict provisions saying that soliciting or advertising your services to clients unnecessarily is not allowed. If you do that also, then that means you are sullying the dignity of the profession or watering down the reputation of the legal profession, so to speak. Personally, I am not sure I agree with this, because there are far too many advocates now. Almost everybody has to advertise their services in some way if you want to attract clients and make money. This is a somewhat crippling provision, but so far the Bar Council has seen fit not to change it, so you must all abide by it. Then Another misconduct could be harming clients in any manner, like if you are grossly negligent in your conduct to clients, like if you do not provide proper legal advice, like if you are just lazy and you do not do proper research, and if you just provide advice to clients based on vague hunches rather than doing actual factual research and providing them, providing them with the proper legal advice, then that is also, you're not doing your duty properly. That's all. Then client confidentiality is very important, like I said. So if you just disclose whatever you have done with the client without that client's consent, that is also a huge problem. Unless, of course, like I said, the crime is very serious, or you could end up becoming an accomplice to crime, or for public safety it is important to disclose it all. Then overcharging or fraudulent billing. Essentially, we all should charge fees. I mean, fees are our basis of sustenance. But at the same time, it's better not to charge fees unnecessarily high. Like, you should charge fees on the basis of the quantity and quality of service you're providing, how much effort you're putting it in. You should try not to charge too much. You should try not to essentially extort your clients. That essentially that would be essentially be behaving like the mafia, which extorts protection money from whatever people reside in their vicinity. So as advocates, we are respectable professionals, and it's our duty not to do that. So like I said earlier, that's what it is. Now also abandonment of client. Now what does abandonment of client mean? As in, if you are in the middle of a case, as an advocate, it's your duty to see that case through to its end. You must try not to abandon the client unnecessarily. I mean, you should not try to chicken out of a case just because you think it's too difficult. You should try to do your best. If you want to abandon it, tell him why you're doing so, and let him know. Let him be able to refer any other advocate he can. Then procedural violations. There are missing. Then essentially, what are the procedural violations? Procedural violations would mean that, let's just say, if you are misrepresenting, if you are not misrepresenting, let's just say procedural violations mean, like I said, when courts, they set hearings, they have specific dates and timings for the hearings. Courts, they have plenty of cases to conduct. So you as an advocate are required to follow their regulations. So if you miss deadlines unnecessarily for no good reason, or if you fail to appear without any justification whatsoever, like say, if you are absent from that case but you are unable to provide a proper reason to the court at the next hearing as to why you were absent, then that is also a serious case of misconduct. It might even influence the court into, you could say, preparing an order against your client, against you even for that matter. Then if client, you must try to conduct the case as much as possible as per what instructions the client provides. Now, if the client instructions are, if you somehow decide to unnecessarily ignore client instructions beyond what is essential as an advocate, then that is also a problem. It means that you are not exactly wanting to do what your client wants you to do. Of course, you can't exactly do anything illegal, but that doesn't mean you should do whatever you want. Client, you are fighting for the client. The client is trusting you to do what he is unable to do. So which is why it's important to follow his instructions. So obviously, then next is disrespectful, improper conduct. Let's say if you are very disrespectful, let's just say that if if you appear before court, if you are trying to on the behalf of a client, but you are not wearing the proper dress, the dress which I talk about, black coat, white shirt, black pant, and formal shoes. If you are not doing it, if you are just wearing casual clothes, or you hear cases of advocates shouting obscene and vulgar language in courts, that is also very bad behavior and a professional misconduct again over there. Then contempt of court. Contempt of court, number one, whenever the court issues an orders, everybody who is a part of that case, advocates or clients, they are required to follow the court's orders strictly. Failure to obey that means contempt of court. Again, there is a specific act called Contempt of Courts Act 1971 which specifically regulates this part. Then when it comes to statements about courts and judges, you are allowed to criticize them to some extent, but making scandalous statements is something you must not do. It's advisable not to do because it could harm your legal career adversely. In fact, even when you make some genuinely beneficial criticism, also it's a problem. There is a very strict hierarchy in courts, almost unspoken one, where judges, they almost boss over junior advocates, and also they don't allow criticism. So it's best to not really try to criticize them in any manner, at least not openly. But man, trying to initiate scandals is even more of a problem. That it could affect your legal career very adversely. And under Contempt of Court Act also it's a problem. Then next is interference with administration of justice. So if there is any so if you are trying to administer, essentially if you are in a court and the court is trying to conduct proceedings properly, this part usually includes, let's say, bribing witnesses. Like if you are fighting on the behalf of a client and there is a prosecution witness who could give potentially damning evidence, then you track him down and you bribe him to not appear. That is interference with administration of justice. Not just contempt of court, it's a serious criminal offense which could result in heavy liabilities. So again, be careful there. Okay, now moving on next. What's the disciplinary mechanism here? The first of all, there is the like I said earlier, when a complaint is made by someone to the bar council regarding misconduct of an advocate, what is the procedure to file that complaint? What is how the bar council investigates that complaint, how it conducts the hearing, and what happens afterwards. Number one, complaint filing. Now, any person who has had a beef with an advocate, a legitimate one, mind you, he can file a complaint with his bar council of that jurisdiction wherever he is in regarding that misconduct. So the bar council, once it receives that complaint, checks for the completeness of that complaint. It verifies the status of the advocate and all, and and whether those allegations made they actually fit the definition of misconduct specified in the case. Then, as I specified in the act, really, what are the misconduct provisions specified in the act? Do those allegations actually fit that? Then they conduct a preliminary inquiry. They examine the complaint. Then they issue a summons to the advocate asking him to respond to the allegations. It conducts a at first sight value of case. Prima facie means at first sight. Then if there is a legitimate prima facie cause found, they issue a show cause notice. That show cause notice, an advocate has to respond, reply to that within 21 days minimum. Then after the response, they initiate a formal hearing. It's not exactly a complete court hearing like in usual cases. It's more of a quasi-judicial, something close to a judicial hearing where both the aggrieved party and the advocate present evidence, and the advocate, of course, as an advocate, he has full right to represent himself, but he could have some other counsel fighting for him if he feels that it is not safe for him to fight on his own behalf. Then the committee would receive examine all the evidence, namely the documents, which were submitted. Then if witnesses are called, their statements would be examined. Then they would establish which evidence carries the most weight, the most importance. In order of that importance, they would establish the sequence of evidence, the sequence of importance in a way. Then after all that, they establish the findings on each allegation. If it is proven, then the punishment for the advocate is decided and a written order is issued. If the advocate is aggrieved by that order, then he can appear to before the Bar Council of India, or if he is not satisfied with the Bar Council, then the final authority of all, the Supreme Court. Usually this has to be done within 30 days, the appeal. And next, so what are the disciplinary punishments? One of the mildest disciplinary punishments is there would be no such, it would just be a simple reprimand or warning. Like if the client wasn't harmed in any way, but the breach was connected, but just very minor, or it was done for the first time. So a written reprimand or warning would be issued. It would be recorded in the file of that advocate, but there would be no suspension. He would still be allowed to practice as an advocate. Now, if they say, now, but if there is a misconduct which causes some minor client harm, like some small amount of money is lost, but nothing hugely major, then there is some monetary fine which is set by the Bar Council. The council decides it bases on how severe the crime was and what, and does the advocate have the means to pay. Then a far more serious punishment is he would be suspended from practice. His license would be suspended for a brief amount of time. It could be typically from 6 months, and it could go as long as 5 years. Again, this is pretty serious. I mean, 6 months is still a pretty long time to not practice. So that's a significant income source lost. I mean, you can't exactly, I suppose you could do other legal work like go to jobs and all, but you cannot practice, appear before court. You cannot draft and sign documents on your own name and so on. Now, if misconduct is even more serious, let's just say your name is permanently removed from the roll, you are debarred from re-enrollment, your name is permanently lost, your name is permanently removed, your right to practice as an advocate is fully lost. That said, if you wish to practice again, and if you are fully repentant or whatever, after 5 to 10 years you could file a reinstatement petition asking to be returned back to your role. Now next, now there comes the most serious punishment. You could even be sent to jail. This usually comes under contempt of court. If you do contempt of court, there are prison sentences specified in that act, where depending on the severity of the contempt of court. So again, this differs. Like what is the nature of the crime you did, how much of an impact it had on the client, if you had any prior criminal history, what is your standing in the community, is there any mitigating factor which lessens the impact of the crime, and is the crime aggravated in any way possible? That's all that stuff. Then next one, moving. Now when these disciplinary orders are passed, like I said earlier, there are several appeals, and you could file appeals against those disciplinary orders, and those disciplinary orders could also be reviewed judicially. Now, like I said, the first appeal when it comes to State Bar Council orders is to the Bar Council of India. Within 30 days, you should of that order, you should file an appeal before BCI. Then the BCI will review that order for any legal errors, like if there was any provision of the law which the Bar Council of India didn't properly interpret, or how to put this, if there was any procedural impropriety, if the proceedings were not conducted properly for any reason whatsoever, or the punishment was way too much, like if it was just a minor offense for which it should just have been a reprimand or warning, but the State Bar Council went way too far and suspended you, that also. So the BCI can either confirm that order, modify it, completely reverse it, or even order a new hearing for that matter. So that's the BCI. Now, if you are not satisfied with the BCI's order either, so what would happen next? If you are not satisfied with the BCI, then you can appeal to the final authority of all, the Supreme Court. Again, within 30 days, you can file a special new petition. The Supreme Court would conduct a limited review for like very serious legal error, not the minor ones, just like very serious, which could have a drastic impact on the advocate and the client. Or if the injustice is a rank one, like it is absurdly clear. So what it can do, the Supreme Court, it can either fully set aside the order, it can modify the order, or it can just send back the order to the BCI for reconsideration, like it often does in other cases as well. So what are the grounds of appeal? One ground would be if the aggrieved advocate feels that the procedure of the hearings and all, the evidence hearing and submissions and all were not properly conducted, if the order contains some errors which were not in accordance with the law, if the errors were factual nature, if the facts were not properly documented or interpreted, if the punishment was way too harsh, then if some new evidence, for instance, if after the passing of the new order some new evidence has come which could not be submitted before, that also you could file in an appeal. Or if the injustice is rank injustice, absurdly clear injustice, then for when it comes to judicial review, there is a standard for that. For that matter, courts, they defer to bar expertise. When it comes, essentially the bar, the Association of Advocates, it refers to, since these disciplinary hearings are usually an internal matter when it comes to advocates, not exactly public cases or client related cases. So they usually defer to the bar. Then review is limited to whether the punishment or whether the proceedings and all were fair, were there any legal errors, as in whether the interpretation of law in the hearing was wrong, and just how reasonable was the order, did it take into account the circumstances or not. Then the appellant, he essentially, if the order was completely unreasonable or anything, that is up to the appellant to prove. The court or the Bar Council of India has no business, they don't have to really go deep in to find out if it was unreasonable. That's up to the appellant. Then there is a criteria for intervention as well. So what is the criteria? Criteria would be, one, court will not disturb proportionate punishment, as in if the court feels that the punishment in the order was more than fair in proportion to the crime committed, then, or the misconduct and all, then it will not intervene. It will only intervene if the punishment is so drastic that it bears no relation to the amount of crime, or if there was no and for that punishment there was no related evidence at all. That's all. So what are the case outcomes? There are some illustrators. The Supreme Court, it has often overturned if during the hearings there was some procedural problems because of which the advocate ended up being unfairly disbarred from practice. The court has overturned that. Then for first time minor offences, if the bar councils unnecessarily suspended the advocates, also it has modified it. Put it this way, the Supreme Court has a lot of power. Mostly the Supreme Court does intervene, but most of the times the Supreme Court will not do so. It only does so in regards to very serious matters. Most of the times the matters do get resolved at the Bar Council level itself, since it's far too much of a hassle at the Supreme Court. Now moving ahead, now there are certain landmark cases relating to this act. Number one was Subramaniam Swamy versus Bar Council. This case, it established the rights of an advocate. First of all, it established that bar councils do have disciplinary powers, but the constitution has also limited those powers to ensure that the bar councils do not become tyrannical bodies. They do not abuse whatever power has been granted to them. Then the second being advocates, they do retain free speech, as in I think it's Article 19 which provides for freedom of speech. So under that article, even advocates have the right to free speech. They can make public statements if they so desire. Then it made distinctions between professional conduct and public speech. Now, basically this case established that if you make statements in your capacity as an advocate, then yes, that is regulated. Like you cannot use vulgar language in court. You cannot make false statements against judges and all, so on and so forth. But as a free citizen of India, as a general citizen without any link to your role as an advocate, free speech is allowed. Then reasonableness and proportionality. It's the case established that conduct rules must be very clear. That is, there should be no vagueness or you could say no shades of grey when it comes to conduct rules. They must be clearly spelled out. They must be precise for advocates to follow. They must be reasonable as well. We must, after all, even advocates are human beings, same as everybody else. We make mistakes the same as the next person. So the code of conduct must be reasonable. It must take into account the circumstances in which an advocate is in when it comes to a particular case. Then whatever disciplinary measures are enforced on an advocate, it must be proportionate to the conduct. It must no disproportionate punishment, like I said earlier. Then this case established advocate independence. Essentially, it said that bar councils cannot control legal interpretation in any manner or impair independent professional judgment. As in, bar council, if a case is being interpreted in a certain manner by an advocate, it is his right. Every interpretations vary across individuals, across professionals. He has his right to an interpretation. A bar council cannot interfere in that. And we as professionals, as persons, we are required to make judgments based on the circumstances, based on what we feel is right. And unless that judgment seriously harms other people, the bar council cannot interfere in that. So how much of an impact did this had on the Advocates Act? So the impact being that bar councils have power, but just like every authority that was established under the constitution, this power of the bar council is reviewable and limited. They are not tyrannical bodies. They cannot just exercise power in any manner they want. If they exercise it in that way, you have the right to file an appeal against them and try to right the wrongs they have committed. Essentially, constitutional limits help to prevent tyranny. Then what is the practical guidance for disciplinary bodies established in this case? So it differentiated misconduct from, essentially misconduct is important to be prevented and regulated in a way, but that doesn't mean you are prevented from making legitimate criticism. Like there are two types of criticism. One is beneficial criticism and the other is destructive one. Beneficial criticism, the one which actually helps the opposing party to improve, is important. It helps. So that sort of criticism must be allowed. And then political participation. Like I said earlier, advocates have had a history of participation in politics, particularly in our independence movement. So political participation is not something to be regarded as a part of our advocate profession. As in, The Bar Council has no jurisdiction or political participation. Advocates are free to join any political party they want, do whatever they want, as long as they do not unnecessarily degrade the profession or violate the rules of the profession. Okay, now there was another case. This case apparently was related to Arundhati Roy. This was contempt proceedings before the Supreme Court in 2010. So what are the facts? So as everybody knows who Arundhati Roy is, so apparently she seems to have made some critical public statements about the way the Supreme Court functions. Now as everybody knows, the Supreme Court is considered the topmost body of the judicial of the country. So it makes sense that many advocates would have been seriously offended by what would have been seen as unjustified attacks on the supreme governing legal body in the country. So many bar members complained against her. So issue was, well, when does criticism is allowed, but when does criticism cross the boundary to professional misconduct? So essentially, every advocate has a speech rights. We have the right to free speech, but how does that collide with our duty to the court? So what was the ruling here? So there is a difference. Criticism is allowed, but there is a difference between criticism and a downright contempt, which is established by the Contempt of Courts Act. So the court established that legitimate criticism is allowed, but scandalous language not so. So the principle which this case established was, advocates, they have the right to comment, like they can make general comments on a case, not untruthful, very harmful comments, but general comments are allowed. And like I said, constructive criticism is important. It actually helps. So again, the court established that that should be allowed. So how does this apply to the act? Now disrespecting the courts, disrespecting the judicial officers who maintain who keep the judicial system up and running, that attracts discipline. But criticizing them like just simple harmless criticism, no, the bar councils cannot punish that. So what was the guidance here? Advocates could engage in public disclosure. They could criticize, but that criticism has to be on merit, as in it should be legitimate criticism with proper grounds for it. They must try to avoid unnecessary scandals, try to avoid unsubstantiated criticisms, to put it simply. Okay, now moving, there was another landmark case. This was Inder Mohan Singh versus Bar Council of India. Now this was about judicial review standards for Bar Council disciplinary proceedings. So what was the case facts here? So there was apparently an allegation of unauthorized practice and financial impropriety. So apparently this Inder Mohan Singh, an advocate, he had been accused of doing illegal practices and being involved in financial frauds and all. So what had happened was, the BCI apparently had suspended his practice. So he had appealed to the Supreme Court. So what exactly happened here? So what exactly was established here? Number one, civil standard applies to disciplinary findings. So what proof is required? One is when whatever evidence is submitted, what was the importance of that evidence? Which evidence mattered more, which mattered less? That order has to be established, and that evidence must also be doubted. There is no it is not beyond reasonable doubt. So again, when it comes to evidence, what was the rule? The findings, whatever the bar council findings it makes, it must be based on evidence, and that evidence has to be credible and reliable, as in it has to ascertain that that evidence has good sources, that the trustworthy sources. So here it is everybody watching this video, those who are advocates or law students know that hearsay evidence, that is evidence which you hear, like say statements made by other parties or written documents which are not completely relevant to the case, which are like secondary sources, those are not really relevant evidence. So again, that evidence is not admissible. Even suspicion, mere suspicion is not enough either. You must have concrete evidence which establishes clear concrete proof of wrongdoing. So natural justice, which includes you must provide a fair notice. The bar council should provide fair notice of a certain time period to the advocate. It must not pass an ex parte order unnecessarily. It must allow him the opportunity to be heard at hearings. Then the adjudicator, the man who the parties who are overseeing the proceedings and who are responsible for formulating the orders, they must be unbiased. They must not be in favor of or against any particular party. They must not be related, to put it simply. Then judicial oversight. There must be a limited but meaningful review. As in, what happens is the courts here, the purpose of this case was to establish that whenever a regulatory body like the bar council or any governmental body, they exceed the limits of their authority as specified by the constitution or other laws, the courts ensure that the limits are established to their authority and jurisdiction. And by establishing those limits, they ensure that cases are not unnecessarily filed, or even if they are filed, they are nipped in the bud before they go on further to waste the time of courts or of the professional or of the advocates or other officials. Then it also established that punishment must fit misconduct. So what happens is, if there is a misconduct which has happened but the misconduct was not too serious, the punishment cannot be too serious either. The punishment has to fit the crime. So if the bar council out of some petty vindictive reason decides to establish excessive punishment, courts can reduce that punishment. Then it also established that bar councils have to prove the allegations. If there are allegations made against an advocate, the bar council has to call for witnesses, has to collect clear, proper evidence, and on the basis of that, they have to concretely, properly prove that evidence. They cannot just make lame accusations here. They cannot just draw conclusions carelessly. And the advocate does not have to prove his innocence. It is up to the bar council to establish the innocence of the advocate or to prove that he is innocent. The advocate apparently is presumably innocent until proven guilty. That's the usual principle of law anyway. Innocent until proven guilty. Every case in India follows that principle. So moving on ahead. Attorney-client privilege, like I said, now again there is also a case law relating to attorney-client privilege, Amarchand Mangaldas versus CBI 2014. So this case, so what did it really? So what was the core rule here? What was it established? One was the confidential communications between attorney and client are strictly protected. They cannot be unnecessarily disclosed. So however, they also established limitations here. What were the limitations? Limitation number one, the privilege only covers the legal advice you provide to the clients. It does not cover any business. Essentially, if you make any business decisions or any decisions which are not strictly speaking related to the legal arena, those are not protected by client confidentiality. Again, this also established that if communications further crime or fraud on the part of an advocate's client, confidentiality does not extend here. Then even if the client has committed a crime, even if the client admits to a crime before an advocate, uh, and he seeks the advice of that advocate, then the advocate is obliged and has a right to protect that communication from disclosure. Then if there is a party which tries to uh, you know if there's a party which tries to force the disclosure from out of the opposing advocate about the disclosure with his client, if they try to invoke the crime or fraud exception, they need to prove that such a thing happened in the first place, or there is a risk of such a thing. Then the privilege, this case established that the privilege is primarily held by the client. The advocate exercises it, but it is the client's privilege that he exercises. If the client waives it, then the advocate cannot exercise it in any way. So what's the summary of this case? One is the client confidentiality privilege is strong. Then crime fraud exception, it's a very narrow window. You must, within that window, you must establish a strong proof. You must present strong evidence to the court regarding that, and the burden of establishing that proof falls ultimately on the claimant, whoever is claiming it. Then conflict of interest, another case law relates to Manohar Lal Sharma versus BCI 2015. So this was before the Supreme Court. It defined rules of conflict and waiver limits. So so what happens is the court held that so what are the types of conflict identified? One was client conflicts, opposing parties or conflicting client interests, financial conflicts, like if the advocate had a financial interest in the client's business or something. Then personal interest, like if the client was related to him in any manner. Then successive representation, like if some former client information which was like say undisclosed information, not undisclosed, disclosed information, which ends up being used against that party. So what did the court held here? So conflict arises when duty to one client conflicts with another or personal interest. Number one. Number two, simultaneous adverse representation borrowed without full so unless there is no consent or without disclosure, without consent, simultaneous adverse party representation is not allowed. It's not allowed anyway. It's a case of misconduct. An advocate is supposed to fight for only one party, technically speaking, not for both parties. Not just like betting on the outcome or something. Then if there is a case of personal conflict, like if the client is related to him or if he's appearing before a judge who's related to him, that's enough for discipline. Actual harm, if it's not necessary that any actual harm befell the advocate or his client. So can the client waive the privilege? He can, if only if it is fully informed. So if the for the waiver of privilege to happen, it has to be completely willing on behalf of client, and it has to be in writing or with his signature on it. So, and it said that some conflicts are unavoidable. So what were the conflict? So that was about this case law. Next up, another case law regarding to fee disputes and advocate compensation. The Harish Kumar Sharma versus BCI 2013. So what did this case establish now? This case established a framework wherein reasonable advocate fees are considered. That is, fees within the parameters of whatever quantity and quality of service you provided. So the core rule is the fees charged must be reasonable. It must be fair. It must be proportionate to the amount of work you have done for the client. Then the case established that written agreement is much preferable. In case of any transaction agreement, written is preferable. Like I said in an earlier video, oral agreements are usually, there is no proof of oral agreement, so it's completely invalid. And before engaging, the advocate must provide full information to the client regarding the case, and the client must be able to have all the information to come to an informed conclusion regarding what sort of fees is he ready to pay and whether it's fair. Again, when it comes to factors, there are for reasonableness there are several. One is how much time did it take for the case to be fought in court, as in for documents to be drafted, to be filed in court, for how much time did it take for the case to be resolved overall. Then how complex was it? Just how many documents you had to draft? How complex was your defense? How uh, how much skill did you exercise? Then experience, this matters a lot. Those who are experienced advocates practicing for like 10 years or plus, they can charge more fees than the less experienced ones. Then customary rates, as in what you must, when you charge fees, you must take into account what fees your fellow advocates are charging for similar cases and for similar effort. Then the Bar Council, according to this case, is fully authorized to initiate disciplinary proceedings for unreasonable fees without properly informing the client. So what are the remedies which were established? The Bar Council disciplinary action is one remedy. Then you could file a case in civil court for recovering the excess amount of fees from the defaulting advocate. You could file a case for arbitration. You could even get a refund order. Like you could have the advocate refund to you the full amount of the fee. So agreement requirements. One is clarity. You must, as in when you make an agreement and you specify the fees, you must specify what is the exact amount of fee. Try not to specify one clear amount. Don't put a range. Then you must disclose it properly. If there are any changes, inform the client in advance, or you could even insert a provision in the agreement stating on what circumstance the fees could change. Then what are the professional standards here? There should be no hidden charges here, as in you must specify the fees and the terms on which payment is to be made clearly. There must be no hidden clauses, no secret riddle like clauses which would which would result in extorting more money from the client without him knowing it. Essentially, transparency, fairness, disclosure, and of course there's some free legal aid duty to poor clients is also important. Then ahead, and there was another landmark case. This related to social media and modern legal practice. Now, as every social media being widespread, like I said in earlier, social media posts are not covered under client confidentiality. Full disclosure, they are perfectly admissible as evidence in courts and in disciplinary proceedings also, I think. So professional misconduct apparently is not limited to just legal documentation or written communication. The nowadays, with the widespread use of social media, the court has also held that the professional conduct rules apply to social media also. So within social media, like say if you are putting a LinkedIn or Instagram post, you cannot just blatantly criticize the court for no reason whatsoever. Proper criticism, beneficial criticism also matters there. Yeah, the court could punish you for a social media post like that, as in for scandalous social media posts. And like I said, social media posts are not exempt from confidentiality, so they are perfectly admissible. Then with the digital age ongoing now, it is completely impossible to avoid using computers or video conferencing or literally any tools to conduct your practice. So the court has permitted advocates to conduct virtual consultations. That is, you did not call the client before you can do video conferencing, or if there are tools, apps available for managing cases, you could use them. Then what was traditionally confidential, it now applies to digital security communication as well. Like if you like make communications through encrypted apps or something, that communication could be protected. digital communication is just as well protected now as traditional confidentiality was, as in traditional documentation. Then when it comes to virtual consultations, it is best to conduct video conferencing. Try to ensure you actually see the client. Or if you are a client seeking an advocate, try to ensure you see the advocate properly. Then when it comes to client, it's best to obtain his consent for virtual consultation, which I think they would give, since most clients are busy and they don't have the time to actually visit advocate office. So they would give consent for virtual consultation, but it's still better to obtain it. Then it is your duty to protect the virtual data, as in the data that is in your computer, the documents and all, Word documents or anything. It is your duty to protect them. Then there are focus now. Now we all use AI to draft legal documents, ChatGPT or whatever other AI apps are available. The court has established regulations for use of AI, for cyber security, for even for crypto payments. Until now, crypto payments are prohibited, but I think the RBI established some regulations, prohibited some, allowing some restricted cryptocurrency deals. Whatever may be the case, crypto payments are regulated. Virtual courts. Now, of course, the virtual courts are not so operational now, but back in the time of the corona pandemic, because we couldn't really go anywhere because for fear of being infected, so virtual courts were literally a thing back then. Now we don't know. It's probably not so much now. So, but yeah, well, it has thanks to the corona pandemic, virtual courts definitely became a thing, and they are also regulated. Like I have attended family law cases where courts, they often, if the witnesses are staying in foreign countries and they cannot appear at short notice before the court, the court itself holds video witness hearings in a way. Then online ADR, that is online arbitration or mediation conciliation also. Then bar council was, what is the response of the bar council? So the bar council has established were a permanent virtual practice guidelines, that is guidelines for practicing, for conducting your legal practice virtually. Then guidance for social media posts, ensuring your social media posts are proper, and so on. Then, yeah, just like in offline practice, the principle behind this case was this: you have to maintain a proper professional demeanor even in the online forum. Even when it comes to putting posts on LinkedIn or Instagram or any other social media, you must try to be as respectful as possible. The social media doesn't give you the absolute freedom to circumvent the rules that was established by this act. That's what this case implies. Anyway, moving ahead. So, although the Advocates Act has had several amendments, the Advocates Act is a very old act, 1961. So, mid 20th century and 21st century, lot of differences. So, plenty of amendments were made here. Obviously, there would be amendments made on the basis of the circumstances. I would wager you the presence of social media, AI, and all that alone would cause some serious amendments. Anyway, in 1973 there was the first amendment. So what was the first amendment? Advocate representation on bar councils was increased further. Then disciplinary with advocacy becoming a widespread profession increasingly, so disciplinary proceedings were also strengthened. Then 20 years later in 93, bar council elections were reformed. I think earlier it used to be some indirect, like how the election of the president of India is through electoral colleges. Now it is direct advocate participation, just like how it is in Lok Sabha elections or municipal elections, you can directly vote. Then national coordination, the BCI is now there, so it coordinates all bar council, all advocate conduct throughout India in all the states. Essentially, it coordinates all the advocates' conduct throughout India, so to speak. Then it also introduced provisions for representation of women in the legal system. Then 2002 May, there was a professional development amendment. So legal education, the continuing legal education, it became mandatory. Then it introduced stronger legal aid for poor citizens and pro bono requirements. Then disciplinary safeguards and appeals were also further enhanced. Then, like I said, 2010 में the digital practice amendment. Now it was here where the amendments took into account the modern world. Electronic filing of cases was permitted, even communication was permitted, especially in case of advocates or witnesses who could not attend court hearings physically. Then it introduced rules for virtual consultations, data protection, as in uh, whatever data advocates maintain with regard to clients in the online media on their computers and all, how to protect them. Then 2015 mein there was an amendment for gender equality. They introduced maternity benefits, I could say longer pregnancy periods for pregnancy and all, as in maternity leave, you could say. And when it came to women advocates, flexible practice. Then when it came to sexual harassment, there stronger protections. There's a specific act for sexual harassment, mind. It's called Protection of Sexual Harassment Act, but we'll come to that in another video. Then when it comes to leadership representation in the bar councils, female representation was increased. Then the latest amendment being 2021 में the practice amendment. Obvious, like I said earlier, when it came to when COVID-19 literally shut down physical courts throughout India, so virtual courts became a necessity. So that practice was formalized post the pandemic. Then it introduced social media conduct rules, like I said earlier, provisions for ADR and mediation practice. And now, when it comes to women advocates, uh, there are many of historical milestones that have been achieved so far. From the time in 1961 when it came in, came into being till 2021. 2021 so far has been the latest amendment. We'll have to wait further for any new amendments in this act. So this act has ensured that when it comes to women advocates, the equal enrollment rights, no gender discrimination here. Then just here maternity leave and flexibility has been introduced for women advocates. Like pregnant, when women become pregnant, their ability to work is severely impaired in many ways. So extended maternity leave benefits and flexibility for women advocates. Women are often tasked not only for professional obligations but also to do the work at home. So flexibility for women is important. So that was also significantly enhanced. Then it introduced, then there were amendments introduced to protect women advocates from sexual harassment and to grievance mechanisms for them. Essentially, it states that bar council must provide forums and channels to redress sexual harassment grievances of women advocates. Then it has also introduced reservation for women advocates in the bar council elections, just like there is in the usual political elections to the Lok Sabha and municipal and Vidhan Sabha elections and all. So there are certain statistics which you can see here. So enrollment has specifically increased a lot for women advocates over the years, as it would anyway. Change is the only constant thing in the world, and things keep on changing through the years. So this is but natural. Then contempt. Then women have faced a lot of challenges here as when it comes to a legal profession. They are hugely underrepresented. Just like even now you see There are women advocates, but even now I think it is believed that advocacy is primarily the prerogative of men. So there is that problem. Then work-life balance, this is very heavy, especially for women. Women, they not only have to do the work in the office, but they also have to do the work at home. They have to take care of the family, get everybody ready for the day and all. So it's too much burden. Then harassment, sexual harassment, just talking about earlier. Men passing, uh, men ogling women and so on. Then client bias, clients probably prefer male advocates more than women. Then pay gap. This is not very peculiar to legal profession. In most professions, this is still the problem. Women are paid far less than the men. It's a common problem. Then what has the Bar Council initiated in response to all this? Women cells as essentially cells for women advocates where they could lodge grievance complaints in case of sexual harassment and all, like, in those cells. Then mentorship programs for women advocates, as in junior women advocates could do internship under senior women and so on, advocates and so on. Specific grievance channels, PD grievance channels for them. Then they have set representation targets where this percentage of the seats has to be filled by women in the bar council elections. So essentially, to put it this way, there has been some progress here, but especially when it comes to senior roles, I think it's pretty familiar. Even now, when you hear of senior advocates or judges and all, it's still by and large men. Moving ahead, when it comes to legal aid and pro bono practice, there are obligations are there. One is the Advocates Act particularly provides for this. So you have to register under a panel for providing free legal aid to destitute clients. Usually 2 to 5 cases per year. Minimum 2, maximum 5. After all, even we advocates have to make money. We cannot provide free service all the time. So typically 2 to 5 cases. It depends based on state bar council rules. It's not uniform. Then minimum hours are recommended by bar council for providing free legal pro bono, that is free legal service to destitute clients, as in clients who lack the financial means to pay the advocates for the proper service. Then fee service, this is discretionary again. Even if you don't want to provide free services, you could provide services at reduced rates for poor clients. This is of course discretionary, but if you do that, it would be a, how could put it, it would reflect on your reputation better. Now legal aid structure, it comes from NALSA, state, district authorities and advocate panel. There is a coordination from the national level. I suppose NALSA is the national level, and it peters down to the state, district authorities and finally to the panel of advocates at the lower level. Then when it comes to charging fees, in this case it has to be lower than the market. If you are doing this, you could do free also, but if you really want to make money, then at least you could charge fees lower than the market rate for similar work. Then if you do this, you could get recognized and it could reflect on your reputation. You could attract more positive, you could attract more profitable cases in the future, as in not only would your reputation improve, but your financial security would also improve. So what is the impact here? Now obviously the constitution makes it clear that financially poor clients should not be robbed of the right to justice, of the rule of law. So again, this provision, it ensures that these people are not deprived of their right to justice. So what are the challenges here? Now obviously, because the fees are so inadequate, not many advocates have the incentive to really do this sort of stuff. So obviously, and even if they do take on cases, they don't really have the incentive to do this thing, to do such cases properly or on time, because less fees means you're not going to get much return in for your effort. So why really take much effort in the first place, right? So obviously there's a huge backlog. Then quality, as I said earlier, when poor people, they lack the resources necessary to afford good advocates, the government appoints advocates for them, but those advocates are often poor in quality. So again, that's a huge problem, because even though you have an advocate, he won't have an incentive to fight for you as much. So yeah, there is still a gap when it comes to poor people and those people who have the means to pay for good advocates. And awareness gaps, but this is related to, this is just that most people, especially the poor people we just talked about, more often than not, they are not really aware of the fact that they have the right to an advocate regardless of how much money do they have. So most of the times they just choose to skip out and live with the injustice. So obviously the advocate participation is more important, but this is going to be more quite difficult. This scenario, I don't see it much as changing. Money is more often than an incentive for all of us, and advocates, like any professional, really want to be paid good amounts of money for good work. So the persuading advocates to provide quality service for this sort of cases will be very difficult, but it must be done regardless. But whether it will happen or not, how much it happens, that depends on how things go ahead. So now, like I said earlier, under this act, if you do anything wrong, you could attract disqualification and removal from the role of advocates. So what are the consequences here? So what are the grounds for one thing? Grounds are, one is, like I said, if you are convicted for a crime on any grounds, that alone is enough to disqualify you. Then financial insolvency, like if you are declared bankrupt officially, that also is one. Then if a medical authority declares you as insane or anything, that also. Or if you do any other professional misconduct thing, like if you embezzle funds provided to you by clients, that is appropriate funds, if you just fail to do your job properly, or if you sexually harass female clients or fellow female colleagues, that's also a problem. So process is, like I said, first of all, investigation is done, show cause notice issued, there's a disciplinary hearing, then a removal order, then you can do an appeal within 30 days. So consequences are, one is you are required to immediately cease practice. You cannot take any further cases or even do conduct your present cases any further. Your status as an advocate, as your status as an upstanding professional, a upstanding member of the community is more or less gone. More seriously, your what you had as a steady source of income, and if not steady, a guaranteed source of income, is also gone. So all that stuff. So what's the way to reinstate yourself? You must, whatever period is there, like for instance, if you are sentenced to prison, you must try to complete your sentence, or you must try to, if you are declared bankrupt, try to get yourself discharged, or if it's you must try to improve your mental health, ensure that the medical authority declares you fit, try to do rehabilitation in any manner. Then procedural safeguards are there. One is right to notice, hearing, counsel, as in you have the right to be provided fair notice of a specific period by the authority. You have the right to be heard. You have the right to be represented by other advocates. You have the right to present reliable evidence during the proceedings. You have the right to an appeal should the order not be satisfactory, and you have the right to have that order judicially reviewed by a court. Then when it comes to advocate rights, there are many common incidents. There are many, you could say, Misconceptions of advocates side. One is confidentiality is absolute. Now there is no such thing as absolute confidentiality. Confidentiality differs. Like I said earlier, if you are helping your client to commit crimes by keeping it confidential, or if it harms the safety of the public, or if you are perpetuating fraud, confidentiality doesn't apply. Advocate cannot refuse any case. If it's best if you try to accept any case if you can. If you truly feel that your client is such a criminally minded fellow that there is no point fighting for him, then don't fight for him. But it's best if you don't refuse any case. Then advocate rights equal general citizen rights. No, it does not. The constitution does protect general citizen rights. When it comes to advocate rights, they correspond duties that you must perform as specified by the act. And like stated earlier, the bar council has the right to exercise restrictions on your rights, especially if you exceed your rights and go and try to insult the courts or anything unjustly. Then bar councils having unlimited authority. They don't. Like the case was established earlier, the courts have the right to they have the right to limit the authority of the bar councils. They could literally reverse the orders of the bar councils or modify them or whatever. So either it's not unlimited authority. Advocates cannot charge any fee. The advocates can charge any fee. No, they cannot. If you as a client feel your advocate is being very unreasonable, you could consult with another trusted person who knows how the legal profession works, and if he feels that the advocate is being unreasonable, you can either switch to another advocate, or if you already paid him, you can ask him for a refund, or if he doesn't issue a refund, file a disciplinary proceeding against such advocate. Professional rules do not cover personal media. I'm sorry, they do. They very much do. Like the cases established, social media posts are not exempt from confidentiality. Sorry, they are exempt from confidentiality. In an adverse way, the confidentiality rules do not apply to social media posts since they are regarded as public posts. So any public posts which degrade the judicial system unreasonably, they are subjected to the act. Removal for role is permanent. It's not. After a couple of years, like it's stated here, 5 to 10 years, or even for that matter, 6 months or something, you could apply for reinstatement. Like if you are sentenced to prison, you could finish your prison sentence and resume your advocate practice, or you could try to persuade the council that you are repentant or that you are in any ways you are fit enough for it. Advocates must disclose all information. That's not true. Advocates have the right, again, client confidentiality is a thing, and if the client discloses to you specific information as an advocate, then you can and should keep it confidential in any manner. Then what are the contemporary challenges here? There are a lot of challenges now when it comes to a practice. One is legal technology. There are several apps now which I myself use an app called e-courts proceedings. I'm sure those of you who practice are familiar with it, wherein hearings of courts hearings in courts are specified, time of hearings and all. Then there's AI. AI, obviously, we draft documents now using AI. So again, there are challenges there. Like I once recently watched a video, a webinar, where a professional advocate claimed that one of his colleagues had submitted he was a very busy man, so when he had been given a case and he had to file a preliminary document before the court, so a summary, needless to say, of a police report. So he had used ChatGPT to prepare that. Unfortunately, what happened was he was publicly embarrassed in that hearing because ChatGPT had created completely fictional case laws. Those case laws didn't exist at all. So again, it is your duty as advocates that if you use AI, just check, just try to check once if whatever the material the AI provides, is it true? Is it, how to put this, does the material actually exist? Does it have a reasonable solid ground? Then remote and virtual practice, again this is a challenge, because clients, especially if your clients are staying very far away and they are too busy or not too inclined to come to your office, then virtual practice is all you could do. There's also virtual courts now. Now that COVID has passed, virtual court is not really much of a thing now, but it used to be back then. So, but even if you decide to virtual court is tough practice, so again you need to formulate your practice properly in regards to that. Then social media and digital co-conduct. Like I said earlier, social media is a huge problem. Whatever post, social media is not as free as we would like. There are regulations here. You can't just post anything you want on social media. You can't post scandalous statements on social media. Those would get you a warning from the bar council at best, at worst a disciplinary proceeding and a jail sentence or suspension of practice. So again, no. Then data protection, privacy, whatever data you use as an advocate, like if you use apps or you prepare documents using Word, protecting that is very important. You installing firewalls or password protection for documents, all that matters. Then alternative dispute resolution law, alternate dispute resolution, new practice laws models, again that matters. Alternative dispute resolution. So again, ADR, now there are online forums as well now. Courts often, if you don't have the time, you could refer arbitration online as well. But again, online, strict regulations are needed for proper evidence submission, proper appointment of arbitrators and so on. Then globalization of legal practice. Now, what has happened is, with globalization being as widespread as it is, advocates coming from abroad to fight cases in India, or our advocates going abroad and fighting cases. You often hear of advocates doing so in America. Then the Advocates Act has established provisions stating that advocates coming from Commonwealth countries are regarded as such in here in India, or those not coming are not so, or plenty of other stuff. Either way, it's a complicated scenario. And not only that, with virtual practice, you could literally fight cases online, even from India itself. Like you could fight case for an American client right from India in an American court. So again, that regulations are being formulated for that as well, because as Indian advocates, it would be a lot of trouble for us to research American laws and fight on the basis of that. Not to mention the system. Here in India, it's a judge system. We stand before one judge and his staff. We fight cases on his behalf, and we represent our clients. We fight cases on his behalf, and there's just one judge before us and his staff. So the judge, we present evidence before the judge. The judge takes into account all of that, and after long hearings, the judge finally decides it. Now, the problem in Western courts especially is the jury system. In Western courts, there is a jury panel. Essentially, the judge is over there is merely an overseer. The case is actually decided by a selected panel of citizens who are well versed in the law of the region. Again, that poses its own problems, because it is not about convincing one man, it is about convincing a couple of people now. So that again is a challenge. So again, as advocates, we have to take into account all of that. It's a lot of challenge. Either way, we have to adapt to the circumstances, do the best we can. So again, there's a practical guidance here, compliance checklist and career framework. You have to maintain an enrollment certificate, and every 5 years. In Maharashtra here it's 5 years, other states it might vary, but here it's every 5 years. If you are issued a COP, you have to renew that. If you don't renew that, you could get listed as a non-practicing advocate by the bar council, and you have to, and to get reinstated as a practicing advocate, you have to submit proof of practice. Then you must uphold honesty, avoid conflicts, protect confidentiality, same as any other profession. Then fee agreements, try to not make vague agreements, try to ensure clear cut fees. Then regular communication is important, try to make the client feel important. If the client feels important, then he would have a good relationship with you, he would be willing to pay you more, your financial security and reputation is intact. Then whatever files you maintain for a case or any case must be properly organized. That way, if you are fighting multiple cases, as advocates we are to fight multiple cases, we would know what to look for. Then as when it comes to court practice, if court set deadlines, we must meet them. If the court calls for hearings, we must appear at the specified time appointed for the courts. This is quite a hassle for us advocates. We have to appear, we have to travel multiple courts at the on short notice, so day gets real tiring. But hard work is what results in success, so it's not much of a choice. Then whatever orders are there, you have to comply with them. Disciplinary risk mitigation, the rules set by bar council, you must know them. When it comes to document communications, you must communicate it to them. Then if there are inquiries made by the bar council regarding uh, disciplinary proceedings and misconduct, you must cooperate with them. Then when it comes to career, your earlier career covers something like 0 to 5 years. Yeah, you do mentorship or internship, legal aid, then bar association involvement. Then 5 to 15 years mid-career, you attain the status of a senior advocate. Then firm leaders. Then if you are working a legal firm, you become some sort of a leader. You could do some teaching in universities as such or colleges. You are qualified to be an arbitrator or mediator or conciliator. Then senior plus years, 15 plus years, you could get appointed to the judicial office, like as a judge or as any other judicial officer. You could even be a leader at the bar council. You could be a mentor or interner yourself. And key resources are BCI, HBC, then whatever publications they do, whatever legal databases they maintain, you could try to access that. Then if you are a junior, you could ask your seniors for guidance, just like any other profession. Essentially, if you want to, so essentially as an advocate, you must try to be competent, as in you must try to know what you are doing, and you must do the proper research in whatever you are doing. Try to prepare for any case well and properly and well in advance. At the same time, you must try to be a man of integrity and honesty. That helps your reputation a lot. Maintain proper documentation for cases. This is something that I will emphasize again. As an advocate, as any legal professional, written proof is always important. It is the #1 priority. Oral proof is never valid. You cannot prove it. The courts usually always accept written proof, written documentation. So maintain written documentation of anything, even the smallest unimportant legal stuff. Maintain legal proof of that. You never know when it could help. So, summarizing this act, the foundational role of the act, this act established the bar councils, like I said, then professional rights, right to practice, attorney-client privilege, heightened duties, duty to client, profession, public, the duty to court, duty to our clients, to the profession as a whole, and to the general public. Then the disciplinary framework established by the act, that is essentially the bar council initiating disciplinary proceedings and so on. Then how the act has evolved through the years and the amendments done. Then contextual context applicable to the act. Then providing free legal equal access to justice to all citizens regardless of their financial capability and all. Then challenges faced in the future, the technological world of today, then how to expand your access to major parts of India and the world, ethical conduct maintained even in the cyber world. Then what are the initiatives emerging? One, practice standards for digital practice, cyber security, so on. So essentially the conclusion is the act, despite it being decades, it still remains very relevant, and advocates have to abide by the act in as much as they can, as much as they should. Only then can our legal profession be safe, our careers can be safe, our financial security can be safe, our the public can be safe, the country itself can be safe, and by ensuring all of this safety, in a way our own personal safety is ensured. By keeping the public safe, by keeping this country safe, by keeping our profession safe, we on a personal level are ultimately safe and sound, safe and secure. Well, that's all for this video. Thank you all for watching this. Uh, Please, if you are inclined to do so, please like my video and also subscribe to this channel my video is in at Siddharth4898. I request you all to please do so. And thank you all for watching this video. Thank you very much. Have a good day, all of you.